Welcome to today's presentation on curing title. I'd like to start with one of my signature Cajun jokes. And since this is Lent, I wanted to tell you one of my favorite Cajun jokes. And let's see, I don't think I use an accent for this one. But this man goes into this bar and he says, I want 3 beers. And he says, I want them all right now. I want them all lined up 3 in a row like this. And the bartender says, okay. So he fixes 3 beers. He puts the 3 beers in front of the guy, and the guy proceeds to drink sequentially each beer. So the next time he comes into the bar and he says, I want, 3 beers. So he does the same thing, all 3 beers in a row, drinks them one at a time. So the third time he comes in, the bartender says, look, I can pour you a beer after you drink it so you don't have to let these other 2 beers sit here and be cold. And the man said, well, you have to understand now, this is a tradition that I have with my brothers. And we said when we were growing up, if we ever lived apart, we lived far apart, that we would at least have a beer together, even if we were by ourselves. So every Friday, each of my brothers goes and they order 3 beers, and it's to represent that we're drinking the beers together. So the bartender says, okay. So the next time the man comes in, he orders 2 beers. And so the bartender pours him the 2 beers and he sets them out in front of him. And the bartender's kind of, feeling with some compassion for him. He says, listen, I just want to say, I know your ritual and your tradition and everything. And I noticed that today you only asked for 2 beers instead of 3. I just want to say I'm sorry for whatever happened to your brother. And the man goes, well, oh, no, nothing happened to my brother. You see, I gave up beer for Lent. All right. Gave up beer for Lent, so he's still drinking for his brothers. Okay, that's enough of that. All right, so today we're talking about curing title. Now, this whole course is on title. So I want you to know how to interpret conveyances. I want you to know how to run the chain of title. And then I also want you to know how to cure title. Curing title is it's a term of art, and it's as if you are fixing it, or you are healing it. So let's talk about the agenda, and then we'll delve into more what we're talking about when we say curing title. So our agenda for today is we're going to look at, first of all, a title curative overview. I want you to understand what the different parts of the title overview is. We're going to talk about what title curative is, what the goal of it is, what the landman does, and then we'll look at the title opinion itself. And I'm going to just break out a very just a couple of pages from a title opinion that I happen to have and show you sort of the key elements of it. And then from there, we're going to look at, once the title opinion is drafted and given to the landman, then what is the landman's responsibilities with respect to that title opinion. And then most of those things are how to cure title, or how to fix any problems with the title. So then at that point, I'm going to talk about the different types of curative documents. These are usually, but not always, affidavits. And so I'm going to walk through some common affidavits, but at the same time, I also want to give you some words that you need to use when you are drafting the affidavit. Remember, you are going to be the person that is going out and securing these affidavits. So that's why it's so important for you to be polite, be respectful to everyone in that town, because you never know who you're going to need to get a title curative instrument from. Okay, so let's just proceed from there and go into what the definition of a curing title. And when we say curing title, to give you a definition here, is it's going through the title and correcting any of the deficiencies on the real property records that's based on a title opinion rendered by a licensed attorney. So what we're doing is we're looking for those clouds on title, or rather the attorney is looking for those clouds on title. They're looking for anything that would jeopardize the marketability of that property. So for example, if it looks like all the elements of a contract weren't met, or it looks like there is some stranger to title, that is something that's going to be identified by the title attorney and spelled out in a title opinion. Now, the goal for title curative is not that we have perfect title. There is no such thing as perfect title. But what we want to do is we want to have what's called marketable title. And marketable title just means that it allows you to hold your property in peace and be assured that no one is going to come and say, hey, you're not the owner, but I'm the owner because of this instrument. So it gives you marketable title. Black's Dictionary, which is kind of the Bible for law students, is title that enables a purchaser to hold property in peace during the period of ownership and to have it accepted by a later purchaser who employs the same standards of acceptability. So it means if you purchase a house, that you should have the right to enjoy that house without having to worry about someone else coming along that was maybe owned it before you saying, hey, you don't really own this property. And by the same token, that the person that you sell your property to is also going to be able to live peaceably wherever it lives, if it's a house, live peaceably in their domain, so or domicile. And so that is what the goal here is. It is marketable title, not perfect title. We'll never be able to iron out every little, cloud on title, every little defect on title, but we're going to get as close as we possibly can to it. Now, a lot of the reasons that we're doing this title opinion, remember, is that we're about to sink a bunch of money into the ground, like $6 million and up. And so we want to be darn sure that whoever we drill on their property, we want to make darn sure that we at least own the drill site. We at least own the drill site. So we will hire a title attorney who will run the chain of title and create this title opinion. So what the title attorney does, he starts where the landman left off. And what he does, and remember he is using, by the way, an abstract of title, which is, from the abstract plant, and they've made a copy of every single instrument that affects that property. Or they may be going online and looking at it online, but they're not like a landman going back and forth to the county courthouse and waiting in line to pull books. So he has all the information that he needs or she needs, and the first thing he does is he or she verifies the chain of title. And so he's going to look at what the landman did, and he's going to look at the run sheet that he created, and he's going to see, where do I see any gaps? Where do I see any problems just in this run sheet alone? And then from there, he is going to identify any defects in title. This is also known as clouds on title. He's going to identify these defects, and then he's going to tell you how to solve them. Now, this is called requirements. This is called the requirement section. So he identifies the defect, and then he gives you a way to solve it. And we'll talk about some of those ways in a minute. And then what he does is, once he does all this, then he's going to issue his formal title opinion. I know when I say his, it could be hers. Y'all know that, right? And so he will issue the title opinion. Now, the title opinion is defined as an opinion by a licensed attorney, and it's based on the chain of title. And what it does is it describes the leases, it sets forth the ownership, and it identifies those deficiencies. That is, any interest or anything that occurred in the chain of title that could adversely affect the leasehold and that might expose the company to liability. And then in addition to identifying that, he also describes it and gives a way to solve it. So here is the top. I think I have this for you in Canvas, but this is an original drilling title opinion. Now you'll see they will use the words original drilling title opinion. This is the title opinion that the attorney sets forth that states that we definitely have a right to be on the property where the drill site is. So this isn't at a unit level. This is only for the exact place that we're going to drill. We want to make sure we have the absolute right to do that, or we will be in violation of trespass, and all that money that we sunk into the ground will be unrecoverable. So let's just walk through kind of one of these title opinions. So here you have your original drilling title opinion, and it gives you the date. So this is an April 21st, 1999 opinion. And then it gives you the client's name. Now this is Rising Star Energy and Collins and Ware, Inc. Now this is important because this title opinion is considered attorney-client privilege, what we call attorney-client privilege. And that means it's confidential. It's confidential between you and the title attorney. Now, in the case of a title opinion, it also means that only these clients are the ones that would be able to sue these attorneys because of a problem with the title opinion. So if for some reason you share your title opinion with a third party, maybe you're selling your property, that third party, if there's any problems with the chain of title, they can't come back here and sue Turner and Davis because it's only as to Rising Star and to Collins and Ware. So that's why they put who the clients are here. And then here it's going to give you a legal description. So it says your Azalea project, all of Section 44, Block 39, Township 2 South, containing 655.5 acres, more or less. And then it goes, gentlemen, at your request, we've examined the following. And then it goes on to say, we've examined all the instruments affecting the title to the captioned land, which have been recorded from sovereignty, don't know what that means now, to March 24th, 1999. They'll give an exact time at 7 o'clock a.m. as reflected by the indices of West Texas Abstract and Title Company. All right, so there's that title company that we're relying on there. Then it will go and say, what is the fee title? If you own fee simple absolute, you own the surface and the minerals together. Otherwise, you may just own the surface, which is called a surface estate, or you may own just the minerals, which is called the mineral estate. So one of the things that he does in this title opinion is he sets forth who owns the surface, who owns the minerals, and what percent each of them owns. So let's look at the next page of this title opinion. And what he's doing is he is then going through and describing each tract. So here's giving you the surface ownership here. And then this is the mineral ownership. Now it gives you a little note here. The tract numbers described below refer to the land described as such tract on the plat of caption section 44 attached. So they have a plat that's attached to this title opinion. And that is what these tract numbers refer to. So for tracts 1 and 2, he lists the owner as Walker Elijah Montgomery as his separate property, and then that is lease number 12. At the back of this, they have listed every single lease. We'll show you that in a minute, what the lease royalty is and what the mineral interest is. And when we talk about mineral interest, this is what we mean by an undivided interest, right? So he owns only 25% and his siblings own the remaining 75%. So that is his mineral interest, his undivided interest. It could be written as a fraction 1/4. It could be written as 25%. But that's what I like to use the term mineral interest. And then it'll go through for each of these leases, say what the lease royalty is and say what that mineral interest is. The next thing is they will list out every single lease that's in that property. And they'll find out where the leases are based on what they found in the abstract company. All the leases that were in that stack of document organized by the land description, they will go through and they will identify every single lease. They'll get the lease date. Well, first of all, they'll number it. Then they'll say when it was recorded. Then they give the lessor's name, the lessee's name, and then the land's covered by that lease. And then it'll say what the interest covered is, an undivided 1/8 interest in tracts 1 and 2, and an undivided 1/16 interest in tracts 7, 8, and 9. It'll say what the primary term is, what the royalty fraction is in that lease, And then it'll go and give any unusual provisions. This is a shut-in gas well royalty. It'll say when delay rental payments are due. In this case, never. It's a paid-up lease. And then it talks about what is in the pooling provision itself. So these are all just spelling out every instrument that's affecting this property, every leasehold instrument that's affecting this property, what their terms are. That's going to help us look at, what royalty rate do we pay this person, and do we pay them their full royalty, or do we have to reduce it by their percentage, by their undivided interest. So all of this information is spelled out in the title opinion itself. Now, at the very back of it is where we get to title requirements. These are title defects, or sometimes referred to as clouds on title. Now, remember, there's no such thing as perfect title. So what he's going to do is going to take the most egregious problems and he's going to put them in as title requirement. And what he's saying is, before you drill, this is what you need to get. And the first requirement is caption land. It'll kind of give you a description of the problem and then how to solve it. For example, the caption land was sold under this application. We cannot determine from the materials examined the classification under which caption land was closed. So this was a general land office lease, okay, and we don't know how they classified that lease. And so the requirement is to submit for examination a letter of classification from the general land office stating the classification under which caption land was sold to H.W. Montgomery, the current owner, under application dated October 26, 1903. So this is telling the landman that they need to go to the general land office and secure what's called a letter of classification under this application of October 27th. The title attorney wants to see that before he clears you for drilling. The next requirement is, we have not been furnished any information pertaining to the status of the ad valorem taxes, the property taxes assessed against the caption land. And so the requirement is submit for examination tax certificates covering all of the caption land from all taxing authorities having jurisdiction over such land. And then here is, we find the following described oil and gas leases whose primary terms have expired, which have not been released of record. And here it gives all these leases that have not been released, and they're going to want you to secure a release from each of these parties. So that's just a very big picture approach of kind of the anatomy of the title opinion. And then it always concludes with, this opinion cannot cover such matters as area, boundaries, location on the ground, or other matters which can be determined only by an actual ground survey. So he's saying, I did not go out to the ground and survey this. And then he signs his name here. The attorney signs his name. So that is what the title opinion is. So again, it's spelling out the client's name, the date, the surface ownership, the mineral ownership, every single lease, and it's giving you requirements so you can fix or cure title problems. So that's what we mean by curing title. Now, when the landman gets this, and sometimes it's the landman, sometimes it's the division order analyst, the landman has to decide which one of these do I want to cure and which one of these do I want to just waive that title requirement. So the first thing the landman does, or the division order analyst does, is they analyze that title opinion. So they're going to read it word for word, line by line. They want to make sure they understand what the requirements are, what the different leases are, what the different tracts are, etc. And then for every requirement, they are going to assess the business risk. In other words, they are going to do a business risk analysis that says, what is the risk that if I don't fix this, or I don't provide this attorney with the instrument he's requesting, that we could come back and get sued? What is the likelihood of that? And then based on that information, the business risk analysis, the expense versus the likelihood of being sued, they're going to decide for every single requirement, do I cure this requirement? That means, do I go secure the instruments that the title attorney is telling me, or do I waive the instrument? So cure it or waive it. Those are the two choices that I have. So let me give you an example of some possible cloud on title. So for example, if we see in the county records Macbeth owns the mineral interest, he conveys his mineral interest to William Shakespeare. The next thing that you see in the chain of title, or that the attorney sees, is that Bill Shakespeare conveys his interest to Hamlet. So here's the issue. Is William Shakespeare the same as Bill Shakespeare? Or was Bill William's son? Or was Bill someone totally unrelated? If it was a son, then they're going to say, well, we need to get the probate records for William Shakespeare, or an affidavit of heirship from William Shakespeare saying that Bill Shakespeare is his son. Or we might get something that's called an affidavit of identity. And an affidavit of identity would just say, I know for a fact that William Shakespeare never liked to be referred to as William. He is one and the same person as Bill Shakespeare. That's the affidavit of identity. So if there's a problem where this is not really William Shakespeare and Bill Shakespeare are not the same person, we've taken care of that by verifying that they are one and the same person. Now, the question then becomes, do we waive this requirement? Do we try to find someone that knew both William and Bill, or knew that William and Bill were the same person, and get them to figure out this affidavit of identity? Or do we cure it? Do we go find someone that knows these people? And the issue here, what the landman has to balance, is what's the business risk, and other factors will play into whether or not he decides to waive or cure. To waive or not to waive, that is the question. That is what the landman is looking at when he is studying that title opinion. Do I waive it or not? Then the next, so let's look at some of those reasons that a landman might have to waive. For a landman, anytime we're dealing with curative instruments, the enemy is time. That means that the landman has to balance between wanting to resolve every single issue that's identified in the title opinion, or risk that a rig that is standing by will get sent to somebody else. So we have really aggressive drilling schedules, and that just puts pressure on landmen and their management. And a lot of times there's just not enough time for the landman to manage all the curative, to get all the curative once the title opinion is complete. So then the attorney, the landman has to decide, do I have time to cure this defect? Do I have time? Also, what is going to be the cost? You know, is it going to be very expensive if Bill Shakespeare is not William Shakespeare? Also, what's going to be the cost to get a broker to go out into the field to find someone that knows both William and Bill Shakespeare? So if, for example, this is an interest in a non-participating royalty interest, we may just decide to waive this requirement because it's not really anything that is resolvable. And the cost of finding that person would far exceed what the lessee believes the risk would be. Now, there are certain requirements that we call unresolvable. In other words, you cannot skip this requirement. So a title requirement can be waived. Unresolvable means that you will never know the true outcome. So it's a title requirement that can be waived where the facts are unknown and can never be established. So let's say William and Bill Shakespeare, you know, were in the chain of title in 1849. Well, there's not anybody that we're going to know who knew Will and William Shakespeare. And so for that reason, because it is unresolvable, we are going to waive that requirement. So that's another reason why a title attorney or a landman might want to waive a requirement that's found in that title opinion. Okay. Another reason that they might want to waive a title requirement is for legal purposes. That is, there may be a situation where the law is unclear. And even if we cured this, we're not sure how a judge would rule on it. So again, the heirs of William and Bill Shakespeare, or around in the 1800s, we're just not sure how that's going to be resolved. Another example for legal is the Duig rule. Is this a situation where they convey half their half interest or half of their half interest? And then if it is that double fraction rule, how is a jury or a judge going to figure out what the specific interests are going to be? So in that case, we would not try to get a quiet title action. We would just waive that requirement. Another reason is that the risk is obscure, which means it's likely that it will never be discovered. Then we'll do a business risk analysis, and we might be willing to waive that if we think that it's unlikely that this would ever be discovered. Okay. Now, there are certain requirements that are unwaivable. Unwaivable requirements are things like letters patent. They want to see letters patent, or they want you to change title all the way back to letters patent. Sometimes in these letters patent, you had to stay on the land for a certain period of time. And so we want to verify that they didn't just purchase the property and then sell it within whatever, a month or something like that. That would destroy the entire chain of title because the first person that owned it didn't really follow what they needed to do to own it. So we need to make sure that we see this letters patent. And again, it won't look like this. This is an original. It will just be a clerk who looked at this and hand wrote in the book every single line of this. And you'll see when you go through those beautiful handwriting. And they literally wrote every single line until you just have a typed out page for the letters patent. But if the title attorney says, I need to see letters patent, you need to produce it. That is something that you cannot waive. The other thing that you cannot waive is a surface inspection. So remember we talked about adverse possession last week, or when we talked about real property law. And one way that you can acquire property is that you can squat on that property for a given period of time, and it's a statutory period of time, usually anywhere between 10 and 30 years. So if they squat on that property for that long a period of time, they could be the mineral owner and not the person that is of record. So the title attorney will ask that someone go out and inspect the surface. Go out and actually physically look on the land and see, is there anybody living there? If we think that the ownership in the surface and the minerals is the same, then we need to go out and inspect that. Now, if the person only owns the minerals and we find that there is someone adversely possessing the surface, then we're going to need to get what's called a use and occupancy affidavit. And what it says is that the person on the land has the permission from the landowner to be there, or they are going to be told that they need to that they're going to be in violation of a trespass action. So that is, the surface inspection can never be a waivable requirement. You've got to look at the surface every time to make sure there's been no adverse possession. Okay, now the different types of curative actions are, one, they might want you to locate missing records. Another is they might want you to record new documents. That's when we're talking about affidavits. And the other thing is they might want you to create some legal action. They might actually want you to litigate in what's called a quiet title action, so we can verify that the owner is who we say it is. So that is the three different types. So let's look at missing records. That's going to be, I want to see any tax records that you have to make sure these people pay the taxes. I want to see all the delay rental payments that have been made on this property so that I can make sure that the lease is still valid. And then they might say record new documents. Now, when we record new documents, this is what we're talking about with typically affidavits. So I want you now to look at some different types of affidavits. I'm going to give you the definition, then I'm going to give you the different types. Now, in Canvas, I do have an example of each of these different affidavits. So I want you to take a look at it, and I lost my train of thought. I lost my train of thought. So let's then look at these different types of affidavits. Okay, the definition of an affidavit is a voluntary declaration of fact that's written down and sworn to by the declarant before an officer authorized to administer oaths, such as a notary public. Now, when we're talking about acknowledging a lease, we're asking the notary public to acknowledge it. And what acknowledgement means is that this notary public is going to verify that the person signing the instrument is who they say they are. So they are the person who is who they say they are. So they're going to ask for your driver's license, and then the notary public is going to verify that you are who they say you are. Now, when we're dealing with affidavits, though, we're dealing with not an acknowledgement, but what's called a jurat. And a jurat basically is a sworn statement before the notary public that says, I swear that everything in this instrument is true. So that is the difference between an acknowledgement and a jurat. Acknowledgement is just verifying your identity, and a jurat is stating that this is the truth. It's like an oath. Okay, so that is common curative documents, the affidavits. Now, let me show you some specific types of affidavits. This is what I have in Canvas for you, and it is adverse possession. It is heirship and marital history, or sometimes it's called an affidavit of an affidavit of heirship, an affidavit of identity, an affidavit of non-production, an affidavit of production, and an affidavit of use and possession. So we're going to go through each of these different types, and then I'm going to give you, but first I want to tell you, if you are the person that's drafting these documents, you need to be careful of the wording that you use in an affidavit. So a lot of times you'll see people say on information and belief. That is not sufficient to cure title. It's not belief, it is fact. So the person signing the affidavit has to say, I know for a fact that this is true. So some of the things that you might say to show that is, based on my personal knowledge or facts within the knowledge of the affiant, and the affiant specifies, the affiant is the person that's signing the affidavit, specifies that all these facts are true and correct. What's not going to help you is if you have words in the affidavit that says on information and belief, on knowledge and belief, verily believes, good reason to believe, believes to be true. We're not interested in your beliefs. We are interested in your knowledge of the facts. So a lot of times you'll see affidavits that have this kind of language in there, and if there's ever an issue where we get sued, this is not going to be sufficient to hold up in court, because no one's really saying for certain, they're saying, I believe, I truly believe it, but we don't care if they believe it. We want to know, do you know it? So let's then look at the affidavit should also contain any explanation of how the affiant came to know these facts. William Shakespeare was my next door neighbor, and he hated for anybody to call him William. So when he turned 35, from that day on, the rest of his documents were listed as Bill Shakespeare. Something like that. You want the affiant to say how they know those facts. Then it will hold up in court. it will be something that we did in fact cure the title, not just someone's belief, but someone's personal knowledge of the facts. So the common curative instrument starts with affidavits, and then the next one is what's called a stipulation or cross-conveyance. Sometimes you will have errors in the documents or in the chain of title, or a lack of properly recorded documentation. And there's some confusion as to who the division of ownership is in the land. So we have what's called a stipulation. This is two parts now, a stipulation and a cross-conveyance. A stipulation just says, two different parts. A stipulation just says, if we want to say that Bill Shakespeare is the owner of the property, we would say, I, Bill Shakespeare, hereby stipulate that I own the blah, 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 blah. You know what a better example would be? Let me do this. Let me do Dewig. So the issue in Dewig was, is it 1/2 or 1/2 of a half, right? Y'all have all watched the Dewig tutorial. So in that case, Dewig would say, I, Dewig, stipulate that I own a 50% interest and that P.V. Moore owns half of that, and P.V. Moore owns half of that half, which would be 25%. And I would own the remaining 25%. So that the interest would be Gilmer, remember this, has 50%. Dewig has 25%. And P.V. Moore has 25%. Okay, that's a stipulation. I am stipulating that this is how the property should be divided. Okay, and then the next part of it is, and if the records show that this is not how they're set up, then I am going to cross-convey. In other words, this affidavit will show that we are cross-conveying to each other whatever we need to cross-convey so that the ultimate ownership can be like this. It's called a stipulation and cross-conveyance. So first of all, you stipulate what you want the interest to be, what you expect it to be, and then you stipulate, and if it's not that, we are going to now cross-convey to each other so that this will be the end result, the 50, 25, and 25 interest. Everybody understand that? That's a stipulation and cross-conveyance. The next kind of curative instrument is a correction deed. A correction deed or a correction lease or a correction description. What that does is it fixes any mistakes that are made in prior deeds or leases or descriptions therein. Now keep in mind, if you are an oil and gas company and you take a lease and that lease had a wrong description in it, and before you can do this correction deed or this correction lease, someone else records, then you don't own the lease. The lease is void. So what we want to do is, once we recognize we've made a mistake, either in the property description or in any of the wording, we want to record of record as quickly as possible a correction of lease or a correction of deed or a correction of lease property description, so that we don't run the risk that we lose the entire lease. Everybody with me on that? So we have correction deeds, we have correction leases, and then we have correction descriptions. So these are all the different correction types that you need to, if you're trying to correct something, you need to record these in the county courthouse. The next thing that we're going to talk about, another common curative document request, is the subordination of mortgage. So if the property has a mortgage on it, think about your house has a mortgage on it. We want to approach the bank and say, look, we know that you have a mortgage on that property, but we want you to subordinate. That means make your interest below what the oil and gas lease is. And the advantage for the mortgage company is that there's not going to be a foreclosure because the oil and gas company is going to pay whatever needs to be paid. What we're trying to avoid is a situation where this property goes into foreclosure and now it has to go to a sheriff sale, et cetera, and then we won't know who we're dealing with, and it's a long bureaucratic process. So we approach the bank and we say, okay, bank, would you be willing to subordinate your mortgage, make your subordinate not the priority, make our lease the priority, or a deed of trust. This is what we're in Texas is a mortgage, and you're going to see that in those instruments you're looking at. So would you subordinate it? Would you put your interest second to ours? And then that way it gives us the right to pay any taxes that are due or anything that would result in foreclosure. Now usually the bank will go for this because they know if there's oil and gas drilled on the property that they will be getting paid, and there won't be any risk that they're going to be, out the money that they put out for the mortgage. So that's another thing, to get a subordination of mortgage or a deed of trust. That way, if there's a lien foreclosure or a mortgage foreclosure, we, the oil and gas company, are protected. Okay, so then let's look at another kind of requirement, and that is releases. So sometimes the attorney will say, as they did in that title opinion that we looked at, was I want you to release these leases of record. That means that we approach either the landowner or the oil and gas company and we get them to sign a document that says these leases on these properties dated this date, recorded in this date, are expired. They are no longer valid, and we release any interest that we had in those leases. That way we know someone else isn't going to come along and claim an interest. We also want the same thing for a deed of trust or a mortgage instrument. We want, once the mortgage is paid, we want to secure the deed of trust or the mortgage that says a release of mortgage or a release of deed of trust. So that may be another requirement that the title attorney puts in there. The last thing is what's called a ratification. Now this comes up in the situations where you're ready to pull a property and you have what's called a non-participating royalty owner who didn't sign the lease. So that non-participating royalty owner hasn't agreed to have his interest pooled. So in order to pool his interest, you have to get permission from him or you have to force pool it. So it's up to this non-participating royalty interest owner whether they want to ratify the lease and therefore accept the terms of the pooling clause, or if they want to be force pooled. We're talking Texas here now, so I just want you to recognize that we need to get a ratification from the non-participating royalty interest owner, and if they won't give it to us, then we have to get a force pooling order. So the title opinion might say, get a ratification from this non-participating royalty interest owner, and then that way we don't have to go through the whole force pooling process. Okay? Another kind of common curative instrument is a request for certified or exemplified, this is misspelled, exemplified copies. That means I want, and this is something that you get at the county clerk's office and they stamp it. I don't know if y'all have seen a certified death certificate, but they just basically certify that this is a true and accurate copy. So they might want certified or exemplified copies of tax certificates. They might want copies of the probate records, any kind of divorce decree, or a power of attorney. They're going to want that to be certified or exemplified. And that really wraps up this presentation on curing title. So let's look at what we talked about today. We first of all began with some basic definitions. First of all, we identified what title curative is, and we said it's a process of fixing or curing deficiencies in the chain of title. And then we talked about what we're looking for when we're talking about chain of title. And we said we're not looking for perfect title, we're looking for marketable title. So there's no such thing as perfect title. There's always going to be some little issue or some little deficiency. And so that's the goal, is that we want to get to marketable title. Then once we have run the records, then we give all the instruments that we have to this title attorney. And the title attorney drafts a title opinion that is an opinion rendered by a licensed attorney that sets forth the mineral ownership. And so his work is he verifies the chain of title, he identifies the defects, and he says how he's going to solve those defects, and he puts all this in a title opinion. Now, and then we went through and showed you the different parts of the title opinion. Original drilling title opinion, I said that was to make sure that the drill site acreage we can definitely have the right to get on the drill site acreage. Now, if the interest is pooled, the attorney is going to draft a supplemental title opinion. Okay, and in the supplemental title opinion, or the unit title opinion, he's going to list who all the interest owner, not just in the original, not just in that drill site, but in the entire unit. They'll list out. And they'll continue to identify deficiencies or clouds on title. And then what will happen is each of these title opinions will go to the landman. He'll make the decision to waive or to cure. And then he will send whatever instruments that the title attorney is requesting back to the title opinion. I'm sorry, back to the title attorney. And then the title attorney is going to let you know whether what you provided is sufficient to cure the title. So they're going to have a first supplemental title opinion, a second supplemental title opinion, third, fourth, fifth, sixth. And all this is, each title opinion is a back and forth between the title attorney and the landman or the division order analyst saying, has this been fixed? Has this been cured? So I wanted you to know the different types of title opinions. Then it goes to the landman. The landman reviews that title opinion. He reads it cover to cover, as does the division order analyst. And he goes through and he makes decisions about, do we waive it or do we cure it? Based on things like the time, the expense, the risk, and the likelihood that we'll get caught. I mean, likelihood that it will be discovered. And then we looked at the different types of curative instruments. It said the most common type is the affidavit, but there's also the stipulation and cross conveyance. There's also correction deeds and leases, correction deeds, correction leases, correction descriptions. And then we looked at the different types of surrender of leases. And then we looked at ratifications. So those are some of the types of curative documents that they want. And then the other thing they wanted was certified or exemplified copies. That could be the tax certificate, that could be the probate records, that could be the divorce decree, that could be the power of attorney. And that wraps up our presentation on curing title. Are there any questions about this? Okay, see, I have a question from Rock. He says, can you really visually inspect all property for squatters? Yes, you can, and you better. If there is a lease on that property, you better either go out physically to that property or fly over on a helicopter. Remember, in order to adversely possess a property, you have to be visible. You have to have put a barn on the land or build fence on the land, or you can't be someone that's just hiding in the woods, okay? You've got to be acting as if that property is your own. And so you build fences, you build a house, you have crops, you have livestock, whatever it is, so that you can then, so that anyone can then visually inspect to see if they're squatters. Now, if you have a property, a lot of times we have these squatters that are in these huge ranches in Wyoming. if there's a lease on that whole area, you better go out and, get in a helicopter or whatever you have to do and make sure that there's no one physically living there. Otherwise, you have this issue with adverse possession. Good question. Anybody else? Any questions about this topic? Okay, if there are no other questions, that concludes this webinar, and I look forward to seeing you in the next one.